إن في الجنة نهرا من لبن.
Bismillah ar-Rahman ar-Rahim. Yesterday we were looking at the principle in al-Qawa'id al-Fiqhiyya, which is known as al-Mashaqqatu tajib al-Taysir. Hardship brings ease. And the Shaykh said that there were many principles that are under this general principle that relate to various aspects of this principle. One of them being al-Dururat tabih al-Mahdhurat, which is that necessities will permit what is usually impermissible. And also a matter, if it is constricted by nature, needs to be expanded. And he gave examples of that yesterday also. And then also that ad-darura tuqadiru biqadriha, that every necessity is commensurate with the degree of the necessity. In other words, a necessity is measured by how much you need based on the necessity. Once you remove the necessity, then the permissibility is removed as well. So that's another. And then also the Shaykh said we looked at the meaning of dispensation or license, which is called a rukhsa. It's something that makes things easier. It's the same word they use in modern Arabic for driver's license. It's something that gives you a permission that you normally don't have. So in Sharia, it's a permission to do something that in normal circumstances it's not permissible, but it's a license to do that. And then the Shaykh said also that we looked at the areas of license. In other words, those areas where the license itself is applied. So for instance, the Shaykh said that generally the basic idea behind this is that the rukhsa comes when a person is in some type of situation that is unpleasant. غير مريح. It's not something that's comfortable, it's uncomfortable. And it differs, and he said we looked at, for instance, traveling. Traveling is difficult when people travel. It's not like being at home where you have everything you need. You go on a journey and suddenly things get difficult, time, and then also sickness. Obviously, if you're healthy, it's much better state, much more comfortable than being unhealthy. And then also coercion, being forced to do something. People normally don't like to be forced to do things, so under duress or coercion, obviously there's different rulings apply. So the Shaykh said he looked at all of these, and now he wants to look at something which is known as al-haja. And al-haja is generally follows darura. It's the next level. It's not as it's a need. It's not a necessity. It's a need. It's not a want either. All right. If we differentiate between needs and wants, a need is something that you can live without it, but it's going to be difficult. Whereas a darura, really you can't live without it. In other words, if you don't have it, you're either going to die or come close to dying. Whereas a haja is something that you don't, it's not an absolute necessity, but if you don't have it, it's very uncomfortable to be without it. And so the Shaykh said that it's important then to see that the haja is less. It's less of a degree than the darura, than the necessity, in that you're uncomfortable. Now he said, for instance, if you look at Ramadan, during Ramadan, when you're fasting, it's not a darura to eat or drink unless you're about to die. Like somebody's diabetic and they can die. But for normal people, it's a haja. In other words, you need water. It's not necessary, but you need it. In other words, it's going to, if you're thirsty, if you're hungry, it's a need you have. And if you don't eat it, there's difficulty. But it's not a difficulty that's going to kill you. That type of haja there in Ramadan is obviously something that you have to deal with. But in other areas where it doesn't relate to a legal ruling in which Allah has placed something on us that has difficulty, in other areas it's looked at differently. So the need becomes something that is going to have different legal rulings again. And then the Shaykh said after haja, he wants to look at 5 concepts that our scholars have brought about. The next one is a manfa'a. And this is really closer probably to, it's something that it's a benefit. It's going to be a little less than a need, but it's going to benefit you. It's going to make things easier, but not to the degree, for instance, that fulfilling a need is. It's a benefit, a manfa'a. So, for instance, Allah subhanahu wa ta'ala mentions فِيهَا مَنَافِعُ لِلنَّاسِ, that there's benefit, manfa'a, like when you go on the pilgrimage, that there's benefits people get. They go and they do trading, commerce, things like that. Those are benefits. They don't have to do it, but they get benefit out of it. Now, the Shaykh said also an example of that would be moving from one house to another. You have a house, it's fulfilling your needs. But to go to another house, there'd be benefits. It's closer to the masjid. It's in a better school district, whatever. There's a benefit in it. So it's another level. And then the next is called zina. Zina is something that makes life enjoyable. In other words, this is something that goes beyond the benefit. This is actually something that's the embellishment or the ornaments of life, without which things would be drab and dreary. In other words, the zina is something, for instance, the Shaykh used an example of women's bracelets. A woman obviously doesn't need to wear bracelets, but when a woman has bracelets, it's something that gives her enjoyment, it gives her pleasure, and it adds to the aesthetic of life. Also, things like clothes, you have a need for a clothes, but putting like somebody that does embroidery on the clothes and things like that, it just gives the clothes something that gives it character. And this is something human beings, really it is a type of need, in that human beings do need to live in aesthetic environments in order to feel good about their life, which is one of the aims and purposes of sacred law. So this is not something against Islam, it's actually encouraged by Islam. And then the final one is called fudul. And fudul is those things that it's excess. I mean, you could argue that bracelets and things like that is excess, but not by Sharia. It's something that's good. But when her whole arm is covered with it, or when they've got, he's got 3 or 4 houses or 5 palaces, or he has a palace in every city. He could stay at a hotel or stay at a friend's house, but he's building that is excess. That's no longer, you're outside of the frame. It's something excessive. So the Shaykh said that these 5 concepts, he wants to look now at al-haja. Bismillah. So the Shaykh said that our definition of al-darura, which is a necessity, is that which makes the impermissible, the haram, the muharram, permissible, and also it removes an obligation that existed before. So for a necessity, for instance, a prayer, if there was a necessity, you can actually delay the prayer until it leaves the time, if it was darura. So there's an example of the wajib actually is removed because of a necessity. And then al-haja is something that, because it's less than a necessity, it neither makes a muharram permissible, nor does it remove an obligation. So the haja does not make something which is haram permissible if you're in need of it, nor does it remove an obligation because you're in need of for whatever reasons, not doing it. So an example of that, the Shaykh said, and also he went on to say that this is in true of the other 3 categories, of a manfa'a, of a zina, and fudul. So the example that the Shaykh gave, a benefit, an ornament or an embellishment, and then excessiveness. The example that the Shaykh gave, for instance, a man who wants to wear dhahab, the gold. This is a zina. Now, the hadith says that the Prophet ﷺ said that this ornament is haram for the males of my ummah. It's prohibited. Therefore, he only allowed gold for the women. So a man is not allowed, just because he wants to embellish himself, he wants to wear jewelry, something like that. He might think it's a zina for him, but it's a zina that the Prophet ﷺ prohibited for his male members of his community, and therefore it is not permissible. And the same is true of the benefit, a manfa'a. For instance, somebody who it would be beneficial for him to get a loan from the bank with usury, because he can invest in things that he wouldn't be able to invest in. that doesn't give him the right to do it by sharia, because it's not a necessity. It's a benefit. And the same is true for fudul. The Shaykh said maybe he wants to build some more houses, so he wants to take out a loan, an interest loan to do that. It's just fudul. So these things, after the darura, they don't. But the Shaykh said he wants to look at al-haja, because some of our ulama have said, indeed, the need does take the position or the place of necessity generally. If you have a general need, for instance, now it's a general need basically for people to use banks. Or a particular need. It might be a need of a woman, for instance, who has to go on a journey. She's not going to die if she doesn't make the journey, but if she doesn't make the journey, it's going to make life uncomfortable, and she doesn't have a mahram. So some of the ulama said, if there was indeed a need, that it is actually to be considered with the same consideration that the necessity does in certain specific examples. Both Imam Suyuti, who was one of the great usuli scholars, among many other things, but he wrote a book, Ashbah wa Nadha'ir, which is looking at things that are similar and how they relate to these rules, how we apply these rules. That book. And also Ibn Nujaym wrote a book with the same title, because this is a science, the science of Ashbah wa Nadha'ir, is really looking at how we apply these rules in everyday life and what's similar to what in the application of these rules. And so, for instance, they mentioned the fact that it's a woman has a need to be educated, and if there's not a woman to teach her, then that need, it might not be a darura, but it's a need. If there's a male, then they say that permits what would normally not be permitted, which is the mixing of men and women. Then it becomes permissible because there's a need there. And also, for instance, salam is a type of buying that involves somebody selling something that he doesn't have in his possession. Because normally in transactions you can't sell something that's not yours. But if we look at how commerce works all over the world, it would make it difficult for people to only be able to sell what they have. For instance, somebody has a shop where they sell parts and they don't have the part with them, but they know where the factory is, they can get it. So he makes the transaction, he says, I'll have it here tomorrow, something like this. These type things, obviously it would make it very difficult. And also hawala, which is also the transference, for instance, transferring things like the person who is put in responsible for something, giving it to somebody else. And also, so some of the even modern ulama have said that we have to allow people to deal with notes of credit and all these bank interest and things like this, because if they didn't, given the way the modern commercial world is set up, we would have all the Muslim companies going bankrupt because they're not able to compete in the modern world of commerce if they're not somehow involved in this ribawi system. So he said some ulama, he's not saying that he says that, but some ulama have actually said that it's a haja, it's a need, and it's a haja, it's a general need. And so the Shaykh said that he wants to look now specifically at this type of, at this these areas in which really, when do we consider a haja to be similar to a necessity, and what are the details of that and the restrictions that we would use in it. So the Shaykh said, particularly in the area of commerce, there are a lot of things that people need to do, but they're not necessary. In other words, they have a haja to do it because of the nature of commercial transactions, but they're not actually a darura. Now he wants to look at something that he said is extremely important, that is mentioned in two books of Imam Ibn Qayyim al-Jawziyya, Fi Zad al-Ma'ad and I'lam al-Muwaqqi'in. These two books, which they cover a lot of different topics, but one of the things that Ibn Qayyim al-Jawziyya, rahimahullah, one of the things that he specifically distinguished between in these books was what is known as muharram al-maqasid and muharram al-wasa'il. And this is a really important distinction, and so the Shaykh said that he wants people to understand this. The basic rule that Ibn Qayyim al-Jawziyah said in his two books was that something that is prohibited because in and of itself, because it in and of itself is bad. It is bad in and of itself. If it is prohibited for that reason, then a need does not make it permissible. Whereas if it was prohibited because it is a means to something that is haram, this is called a wasila, then in times of need it becomes permitted. And the reason for that is because it is not bad in and of itself, but it becomes bad because of what it leads to. So for instance... نعم.
محرم المقاصد original. original.
Yeah.
محرم المقاصد.
Right. نقول أنه محرم
الذاتي
ومحرم في ذاته ومحرم.
نعم. تمام.
So the Shaykh was just saying that you could say something that's muharram because of that in its origin it's bad, whereas the other is that it's muharram because of what it leads to. So this is the difference of maqasid. Maqsid is something that's the aim or purpose of it. So the tahrim, the prohibition, is because the thing in and of itself is something that the Sharia is trying to stop. Whereas when the prohibition is for a wasa'il, it's the means to something else. So you cut off the pretext, you cut off the means. So the Shaykh said, for instance, Allah subhanahu wa ta'ala says in the Quran about khamar, that khamar, gambling, wine, intoxicants, gambling, wine, divination, the throwing the arrows of divination, which now would be like the occult, astrology, and all these type things, is foulness from the actions of shaitan. In and of itself, it's bad. And so Allah subhanahu wa ta'ala says, so avoid it. Fashtanibu means, avoid it. It's haram. Don't go near it. So that is tahrim al-maqsid. Now, there's a hadith in which the Prophet ﷺ said, do not sit at a table that has wine on it, that has intoxicants on it. That is not haram because sitting at a table is haram, or that has wine on it. But it's because there are many things that could come from that. Somebody could see you at the table, think you're drinking. You could end up being enticed into drink. There are a lot of reasons that could come from that. So you can see that the prohibition is because of what that can lead to. And that's called a wasila. It's also called dhari'a. So the Shaykh also said, Allah subhanahu wa ta'ala has prohibited fornication and adultery and homosexuality, all of these things. But there are also prohibitions that are not, because it's bad in and of itself. It's tahrim maqasid there. The fahisha, Allah says that it's sa'a sabila, it's a horrible thing. Whereas with the wasila, we're prohibited. Allah says, قُلِ الْمُؤْمِنِينَ يَغُضُّ مِنْ أَبْصَارِهِمْ. Say to the believers, lower their gaze. Why? It's not the gaze itself that is haram. It's that the gaze becomes a means. Because you see something, you're attracted to it, one thing leads to another, like they say in this culture. So the eye, flirting, all occurs with the eye. If you like these bars, people go to singles bars, it all begins with the eye. You make eye contact with people. And so that is what, it becomes a means to the haram, which is fornication. It doesn't mean it won't necessarily happen, but because that possibility is there, the Sharia is a preventative Sharia. It's trying to prevent people from getting into trouble before they get into trouble directly. So these are all tahrim of masail, wasail, and Allah tells the believing women also to do that. Now, if you look at a woman who's, the Prophet ﷺ prohibited a woman from traveling a journey greater than a day and a night. Without a mahram. Mahram is a male, legal, intimate, a relative, a brother, a father, a son, a male legal intimate that can travel with her. That prohibition is not tahrim al-maqasid. It's tahrim al-wasa'il. Because for many, many reasons that you could go into, that she can be accosted, raped, things like that, or end up getting in illicit relations, many type things that can come from that. But the Prophet ﷺ prohibited it. And also, then the Shaykh said that if you look at this distinction that Ibn Qayyim al-Jawziyah made, radiyallahu anhu, he said that if the prohibition is for the maqasid, then it is not permissible to allow it if you have a haja. It has to be a darura. But if the prohibition is wasa'il, in other words, the prohibition is because of means, then when you have a need, it becomes permissible. So for instance, in the case of somebody who's traveling and he needs to eat, he's not going to die yet, but he needs to eat, and he goes into a restaurant, and the restaurant, there's a table and there's wine on the table. And if he doesn't eat, it's going to be difficult for him, and they say if you want to get served, you have to sit at the table. We're not food to go. In that case, it would be permissible for him to sit there because he has a haja, and the tahrim is tahrim al-wasa'il. It's a prohibition of means, not a prohibition of aims and purposes. Also, a woman who needs to travel. She has a serious need. It's not a necessity. She's not going to die if she travels. But there's a need. And she doesn't have a mahram who can travel with her. In that case, according to this opinion, it would be permissible for her. Another, which is clear in the Sharia, is Allah says lower the gaze. Why? Because He doesn't want people to fornicate. But if somebody wants to marry somebody else, the intention is not to fornicate, the intention is to get married. So it's permissible for him to go and look and see whether he's attracted or she's attracted to the husband, to the potential suitor. So there, it's permissible to look and to see and to see the beauty of the person with that intention, to see whether there's an attraction or not. Why? Because this is a wasila. And the Prophet ﷺ said that, told the man to go and look at the woman so to see if he's attracted to her. Even though normally he would never tell anybody, go look at that woman, see if you're attracted to her, unless he had the intention of getting married. Another example, so the Shaykh said it's important then that we realize there are two types of prohibitions in Sharia. There is what is muharram, because of the aims and purposes. In other words, it's in the language of the Western legal theory, they say bad in and of itself. It's prohibited because of that it's foul in and of itself. And the other is it's prohibited because it's a means to something that is wrong. And so the Shaykh said, another example, he said, therefore, the wasa'il, the means to the prohibited, can be removed out of need. So, a clear example of that from the Sunnah is that the Prophet ﷺ said, do not sit on the roads. They said, Ya Rasulullah, we have to do it. In other words, we need to do it for our commerce, social life, etc. He said, well, if you have to do it, then observe the haqq, the right of the road. And they said, what was that? He said, lowering the eyes, amr bin ma'ruf, commanding to good, forbidding evil, guiding the person who asks you if you need help. These are the rights of the road. So the wasila to the haram is sitting in the road could lead to something haram. But because there's a haja, the Prophet removed the prohibition with those conditions, that you observe the rights of the road. So the Shaykh said this is the nahi is called nahi al-wasa'il or al-dharaya', and he said that these are examples. Now he finally mentioned that Ibn Qayyim al-Jawziyah radiyallahu anhu is really the first alim, even though that this was understood before, he's the first alim to clarify it with this clarity, that this is an original contribution from the Imam with this clarity, and mentioning it in both his books. And the Shaykh actually did a paper on this, and he was also asked recently by the Majma' al-Fiqhi, the Supreme Council there in Jeddah, to write something specifically about tahrim al-wasail and the haja, because so much of modern transactions involve this really important aspect of it. And also the Bank of Development asked him to do that as well, because they have all of these transactions. They're trying to work out how to do it and to stay within the boundaries of the Sharia. So the Shaykh said that what he's gone over are the most important aspects of this very important universal principle, which is al-mashaqqatu tajlibu at-taysir, that hardship brings ease. He said that we looked at the what's known as mashaqqa sughra, the lesser hardship, the kubra, the greater hardship, and then a thalitha, the one that's between the two. Which one does it go to? The Imams differed on that. We looked also at the idea of the rukhas, which are legal dispensations to do things because of difficulties. And also we looked at some of the areas in which we implement the rukhas, like traveling, sickness, coercion, duress. And then he said we looked at this particular problem, which is known as al-haja, the problem of the need, those matters that involve the needs of human beings. And we looked specifically at the opinion of the great scholar Ibn Qayyim al-Jawziyah, radiyallahu anhu, who said what he said, what the Shaykh had just gone over. And he said that this probably is one of the principles that has the most, it's the most extensive of what we've been looking at. There's a lot of applications of this, but the Shaykh said, unfortunately, due to the constraints of time, he wants to finish the 5 most foundational qawa'id of our jurisprudence, and so he said he's going to stop here with this qa'idah and move on to the next. So the Shaykh said, before we move on to our next section, he said he finds, after he talks about these things, he tends to be a little cautious and find something in his self that gives him a little concern. And that is because people have to understand that this is a big area of debate amongst the scholars. Imam Shafi'i radiyallahu anhu said that a haja is not like a darura. That a darura is the only thing that can make what is prohibited permissible, and not a haja. And he said probably the first scholar that really opened up this door was the great scholar from the Eastern Persia, Imam al-Juwayni, who's known as Imam al-Haramain, because of the time he spent in Mecca and Medina. And he is one of the greatest Shafi'i jurists, and he actually he's the first one to really explore this more fully. And then his student also, this is the 4th, early of the 5th century, his student Imam Hujjat al-Islam Abu Hamid al-Ghazali radiyallahu anhu, who was a great usuli scholar also, he also inclines towards this position in some of his positions. But it is Ibn Qayyim al-Jawziyah who really made this very fine distinction of when the haja, when the need is considered similar to a necessity, and that was when the prohibition is a prohibition of the means to something haram, and not because the thing in and of itself is haram. And so the Shaykh wanted to say that given that most of the people here, he said, are at a very beginning level, that really what we're looking at is related to the philosophy of legal theory. I mean, this is the philosophy of law. It's really looking at the philosophical nature or the theory behind Islamic law. And he said that while it's really traditionally more of an advanced study, he said that the fact is that where you are now, you're obviously engaged in a lot of these issues, so he felt that it was worthwhile to go into detail about this particular issue, realizing that people have need of it in their daily lives. And then the Shaykh said now he wants to move on to the next principle, which is known as al-urf al-muhakkam or al-'ada al-muhakkama. And al-urf and al-'ada is what we call in this culture, we call it the customs of a people, the habitual nature of a people, those things that people do as a customary practice. And every peoples have their customs. And so the principle states that the custom is considered in legal judgments or rulings. The custom of a people is legally considered when we have legal rulings. So the Shaykh said that from this principle, which is that people's customs are legally considered, that he said we'll come to know what the role of the customs of a people are, what the role of their traditions are. Do they indeed affect the rulings or not? And the Shaykh then said that in the Sharia, some rulings are affected by custom and others are not. And that distinction is important. First, he said, let's look again at what this principle is contained of from words. What do the words mean? There's basically two words here, al-urf or al-'ada and al-muhakkam. And the Shaykh said that al-urf are those things. Urf in the Arabic language is a word related to the verb that we know, arafa, to know something. Yata'araf alayha an-nas means those things that people commonly share. They have a common knowledge of. In their, for instance, you have customary sayings in American culture. You have idioms, what they call idiomatic language. This is the custom of people. They're not the same as in England. Or you could have the southern people like this. So the customs relate to those things that are habitual in a people, and the people know about them. Another aspect of the urf is that usually people do not know where it originated. In other words, it's something about customs of a people. There's an element of mystery in who was the first person that ever ate on a chair or ate on a table. Who was the first person that ever ate with a fork? We don't know that. It's the custom of the Arabian people, the Shaykh said, to eat with their hands. It wasn't their custom to eat with utensils. But other people, like the European people or the Western people now, it's their custom to eat with utensils. Although we know that it's also custom to eat certain things with their hands, like chicken. So this is a custom of a people. Now, the Shaykh said that the second word here, muhakkam, means that it can actually become part of the legal ruling. So it is considered in legislation, it is considered by the judge whether or not it actually does have a hukum in sacred law. So the Shaykh said when we look at what is the origin of this concept of urf and that we consider it in sacred law, he said that there are many verses in the Quran and also hadith that indicate clearly that the custom of people is indeed practiced. For instance, Allah subhanahu wa ta'ala says about divorce. When divorce occurs, there's something which is known as the mut'a, which is something that man gives to a wife as a way of easing the separation. It's an easement. It's not an obligation, but it's something that is a good thing to do. And it's in the Quran, Allah says mata'an bil ma'roof. Bil ma'roof is what's known, what's the custom. The ma'roof is the custom of a people. It's what everybody knows. And this, obviously, the Quran did not say 10 dinars, 100 dinars. It didn't say that. It just said bil ma'roof. And that this is something that really is an obligation on people of ihsan, the people of that do good, muhsinin, al-muhsinin. And so he said it's the nature for a stronger one, a husband stronger than the woman financially, to give the weaker of the two some type of gift. And he said again that this goes back to the custom of people. What is the custom of the people? Also, Allah subhanahu wa ta'ala says concerning the maintenance that a rich man should give what he's able to give, according to ala qadrihi, according to his ability. A poor person should give according to his ability. Again, this is urf. What does a rich person do in that? What's known amongst people? What's the general custom of the people? And also, somebody like a woman complains to the judge and says, my husband's not giving me what I'm entitled to for my status. Well, the judge would look at what their level of income was and what somebody of that level of income in the society, in a normal circumstances, how much they're getting. And that's how it would be determined. Also, in expiating of an oath, if somebody makes an oath, Allah subhanahu wa ta'ala says that they should feed from a food that's So the Shaykh said, just to give an example about language and the imprecise nature of language, the Shaykh said you have certain words in Sharia. Just to take an example, you have a word qabd. Qabd means to possess something. Qabadtuhu means I grabbed it or I possessed it. And also hawz, which has a similar meaning. Something comes into your possession. And then hirs, which is some type of protected area, is called a hirs. It's a protected area, usually something that has a fence around it, something like that. Now, there's a hadith in which the Prophet ﷺ said, whoever is going to buy some food, then he shouldn't sell it until he actually takes possession of it. حَتَّى يَقْبِضَهُ. So that hadith is very clear. Now, Ibn Abbas radiallahu anhu said that I include in food everything else, that you shouldn't sell something until you have possession of it, until you take possession of it. So from that, what the question arises, what exactly is qabd? حَتَّى يَقْبِضَهُ. Because in the custom of a people, it's going to differ. The Shaykh said, for instance, al-qabd can sometimes mean that somebody has given something to somebody else, that they're free of it now, and now it's been in the possession of the other without actually having a physical transaction. Like what occurs in buying and selling here, in buying and selling houses. There's actually the possession exchanges without having the actual physical, you don't necessarily get the physical house itself. And yet the transaction's been completely changed. So the Shaykh said an example of this is a boat carrying rice from Pakistan. And he's going to use this because this happens a lot in Saudi Arabia, that they eat a lot of rice and the rice comes from Pakistan. So you get boats coming from Pakistan, and they have a port in Jeddah called Mina Jeddah al-Islami, the Islamic port of Jeddah. And so the Shaykh said that if you have a boat out on the waves, you bought from Pakistan this food. You purchased it, but the boat's coming. You actually haven't taken qabl of it. You don't have possession of it. And yet you sell it in the suq. This is because now, in the custom of a people, tasjil, when you actually put something down in these letters of credit, when there's exchanges and people, he's the registered owner. Even though he hasn't actually bought it. He made a phone call to Karachi, the man there sold it, it came. He's the registered owner. So when it arrives and he goes and collects it, people give it to him because he is the registered owner. So in a sense, that he has qabd, he has possession. It's not physical possession, but it's possession in meaning. So he is the owner of that rice, and therefore he can sell it. and this is again, he said, Ibn Qayyim al-Jawziyah, rahimahullah, and he said that Ibn Qayyim, who was a student of Shaykh Ibn Taymiyyah, he said that there are those. He said Ibn Qayyim really had an absolute legal genius. He had a massive intellect, massive understanding, and he said that there are some people who actually prefer him over his teacher in his understanding, and he said he tends to incline towards that. He said again, Ibn Qayyim made a distinction between the qabd of possibility, taking possession, that it's possible, but imkan, and also the physical muknati, that you actually have it in your hands. So he distinguished between the ability to get it and actually having it. If you have the ability to get it, it's yours, and it has the same meaning of qabd. And then another one is the hawz. So hawz is something that you have in your possession, fi hawzati, like it's in this book is in my possession. And how does that translate into the urf? Because, for instance, the Shaykh said if you give your son a house, for instance, it might still be in your possession, but now you've given it to him. So even though technically it might still be in your possession, it's gone to him. The ownership has gone to him. And then also the Shaykh said that in the hirz, which is it's something that is an area, a safe area. For instance, he said in the desert you have areas that they'll just take some thorns and they'll put the thorns into a circle. And that's where they'll put the sheep or the goats. Now, if somebody came and stole the goat out of that circle, if he's from the desert, he knows that belongs to somebody. It's a hirz. And so, technically, he's considered a thief. Whereas, if you have that type situation here in in a cultivated place or so-called civilized place, then you don't consider that. You'd need to have a fence, a proper fence, something, in order to be considered a hirz, like a gate or a fence. Another example also the Shaykh said is wadi'ah, which is a deposit. Somebody who leaves something with you, deposits something with you as a trust, like a security deposit. For instance, people have safety deposit boxes. That's a wadi'ah. You leave something in the trust of somebody else. Now, normally, that person's not a guarantor, a damin. But if the person, for instance, took that wadi'ah, went down to the marketplace, and he just put it down and said, I'll come back. It's a little heavy right now. I'll finish my shopping and then come back and get it. And it's a bag full of money. And he comes back and the money's gone. Then in that situation, he has to recompense, because it was a trust and he didn't fulfill the trust by putting it into a secure place. So a deposit by nature has to be a secure deposit. Even though it was still a wadi'ah with him, it changes based on what people understand to be common sense, to be the custom of the people. It's the custom of people, if I entrust you with money, that you don't just leave it on the supermarket counter until you finish your shopping. Nobody would accept that. So the urf then is how... and also the Shaykh said in exchanging money, when you go to a money changer, like in Arabia, when you change money with them, it's yadan biyad. That's what understood with sarf. When you change money, it goes hand to hand. But, for instance, traveler's checks. Now, people use traveler's checks, and even though it's not technically the money, it's become to represent the money. Even though it was issued by a bank, it becomes to represent the money, and you carry it with that understanding that people are going to take it as if it was cash, because they're giving it the position or the authority of cash, because this has become the custom of the people to use those things. They weren't used before.